Welcome to this free immigration help channel. Today is May 30, 2023, and we are getting into the volume 103 of me answering your immigration related questions. As always, before beginning, I'm going to mention I am not an immigration attorney. This is not a legal advice. All the information provided in these videos on this channel are directly from official government sources like USCIS, of course, and the Department of State with their visa bulletin. So, as you can see, I have all your comments pulled up in front of me. Let's start with the very first one from Lana. Hello, I'm a permanent resident of the USA and I filed an I-130 to be reunited with my adult unmarried son. USCIS approved my Form I-130 and wrote that I needed to submit Form I-824 because I didn't write an address in one of the fields on Form I-130, that without Form I-824 my case would be suspended. I filled out, paid for, and submitted Form I-824 with receipt. My USCIS account now says they have received my Form I-824, but where the Form I-130 information is, they wrote that the case is closed. Please help me to understand, is this normal? And do I have to wait calmly, or does this mean that the process of my case is completely stopped and I need to reapply for reunification with my son? I can't call them, I wrote to them, but they do not answer me. Lana, it sounds like everything is going good with your case. You have satisfied the requirement that they had for, updating the address that you have missed on the Form I-130. When online, in the online USCIS account, when it says that the case is closed, it's good. It's good because it means that that's it. You got the resolution. So now the next step would be dealing with the NVC and becoming documentarily qualified. So I'm gonna recommend, depending on how you specified your contact information in the I-130, whether it's just the address or if you did specify the email address, which is very nice. And I think you will get it in the email. Why? Because you do have the online account for USCIS. USCIS already sent your case to the NVC, so you should be receiving the emails from NVC pretty soon. So check the spam folder just in case, not to miss them, but they will be from the NVC, from the Department of State. The emails will include the case number and the invoice number, the two numbers that you will use in order to log into the online NVC portal, where you will continue the process of basically the family reunification. Now it's in the next stage, is becoming documentarily qualified. You will be submitting the affidavit of support, paying for the visa fee, all that sort of stuff. I actually do have a separate video. It's called Documentarily Qualified. What does it mean? I definitely recommend checking it out, because in that video, and it goes for everyone, if you're starting your I-130 petition and you did not get to the NVC portal yet, check out that video, because in that video I show the real NVC portal, that the person that was already documentarily qualified, in fact they already got their permanent resident card and everything, but you can see what fees are there, what you will need to fill out, what documents you will need to provide, financial documents, civil documents, so you can be prepared. But Lana, I think everything is going well. You shouldn't really worry about anything. Just make sure you're staying on top of your email and not miss that, because personally I got the first time I received that email, it actually went to spam folder, which is weird because it's .gov. But let me put this and we're gonna move on to the next question from Hazards. Hello sir, I have applied for the immigration on 14th March of 2016. Now my case has been approved by USCIS and NVC has sent me the notice of being documentarily qualified. Congratulations, that's a huge milestone. My visa class is F11, F1, subcategory F11, unmarried, 21 year and above, son, daughter of US citizen. I fall under all chargeability areas. How long should I expect for my visa interview to be scheduled? I was documentarily qualified on 15th of April 2023. Thank you for your response in advance. Hazards, I want to say thank you for providing all the needed information for me to make the best possible prediction estimate, because you really provided everything that is needed. So let's go to the visa bulletin and we're going to take a look. So we know that the priority date is March 2016. We know that it's F1 all chargeability area and it's already documentarily qualified. So we're going to be looking at the graph A, which is the general graph for the availability of the immigrant visa for those people that are already documentarily qualified. That's why it's called final action dates, meaning that the final action was already taken, and final action being being documentarily qualified. So if we look at the F1, we see that right now it is showing December 14. December 14, people with the priority in 2014, as of right now, May 2023, June 2023, their immigrant visas just now becoming current. Well, their priority date is becoming current and their immigrant visas are becoming available. So we're going to take a look. There's March 2016. So that is about roughly a year and 3 months. A year and 3 months. So a very rough estimate hazard would be a year and 3 months more wait before your immigrant visa is available. Of course, we have to take into consideration that the backlog unfortunately keeps on growing. So by the time you get, by the time 1 year elapses, there might be some backlog accumulated, and as a few months, it's possible. You also have to keep in mind how busy the U.S. Embassy is in, let's see, did you tell me which one? I think you just said that it's all chargeability. Yeah, under all chargeability area. Depending on which country you're in, U.S. Embassy in that country might be a little bit busier. It might be a little bit, more flexible, relaxed schedule. So once your immigrant visa is available, it's their job to schedule your interview. And again, you might experience, here and there, a couple months, few months before they schedule the interview. But a very rough estimate, about a year and 3 months. So I would say by the end of 2024, you should definitely have your interview, and you should definitely have your I-551 stamp in your passport. But congratulations on pretty much completing everything fully. Becoming documentarily qualified is a huge step, and that's already passed it. So now the only thing is left is just going through that interview. And the medical examination, of course, now without that one. Alrighty, let's move on to the next question from Sirgut. I can't read this, but I know it is Sirgut. Sirgut, thank you for another comment, appreciate it. And thank you for being publicly subscribed. This is what this icon means right here. Sirgut says, hello brother, I asked about the status of my case to the embassy a week ago by email. Today I received this email. At this time, this case is undergoing a mandatory review by the adjudicating officer. Once the review is completed, we will contact the beneficiary. Brother, what will happen next? Is that a good news? I think they will inform me about my interview appointment. Please explain to me. I asked you when I was confused and you told me to ask the embassy. Thank you very much. You're a very good person. So good. Appreciate your kind words. This is just typical boilerplate response. I mean, there isn't really much to review. You're already documentarily qualified. You're just waiting for your embassy interview. So there isn't really anything that needs to be reviewed. So this don't really, don't be too upset that they didn't give you any specific information. A lot of times that's how it is, that's how they are. They don't provide any information, they just give you a boilerplate response. There is really no mandatory review that is happening by adjudicating, because it's already reviewed. You're already documentarily qualified. The only thing that needs to happen is they need to schedule the interview. So unfortunately, the only thing I can tell you is just some more patience, and that's really it, unfortunately. So sometimes some of these cases, not some of these cases, really any kind of immigration case requires, unfortunately, patience. But you did everything correct. You already passed all of the difficult stuff. So now it's just a little bit more patience and waiting for that interview to be scheduled. But again, as always, as I say always, once you do have the interview scheduled, please come back and let us know, because it would be very helpful. Because I'm also waiting for your interview. And I know you've been waiting for a long time too. So I am excited for you, and for everyone who's going through their interviews, because that is the final. That's it. You go, you get that visa, and you're done. That's it. Alrighty, let's move on to the next comment from Santiago Simerin. Santiago, thank you for another comment. Again, appreciate your subscription, public subscription, that is. Thank you so very much for taking the time and responding to this. Is in such a personalized manner. You pronounce it well. Thank you so much, Santiago. Santiago, you're very welcome. I'm glad you found my answer helpful. Moving further to Philip Thomas. Hi, sir. Thank you very much for considering my question and for the valuable information for me and for many others as well. May God Almighty bless you, Philip. Thank you very much. Appreciate your kind comment. Alrighty, moving further to Michael Cordenillo. Sir, I'm from the Philippines. My interview hasn't been scheduled yet, but I want to get started on my medical exam. Where should I go to get an exam? Petition for parents. Michael, unfortunately, that's a great comment, great question. I'm sure some people might find this helpful. Unfortunately, you cannot do the medical examination until the interview is scheduled, because they schedule the interviews to keep in mind that. So this is how it works. Let's say today is May. Well, not let's say today is May 30, right? Let's say June 1st, you have your interview scheduled. Most likely it's going to be scheduled June 30th or June 31st to give you 30 days. They give you 30 days because your medical examination cannot be 30 days older, or I think it's 60 days older, but whatever. They give you 30 days so that it's not older a certain amount of time before the interview. That is why, unfortunately, you cannot go and do that medical examination beforehand, before the interview is actually scheduled, because they must have these results of the medical examination very, very fresh, very recent. One recommendation, though, I will give you: once your interview is scheduled, then you want to do it as soon as possible. Don't wait too close to the interview date, because I have actually seen personally a case where a person waited like 5 days before the interview, and then they went and did the medical examination, and when they went for an interview, they were told that unfortunately they have not received those results from the doctor yet, so they had to reschedule the interview. You definitely don't want to do that. Alrighty, let's move on to the next question from Paul Adam. I'm sorry for mispronouncing the name. I am in F1 category. I am unmarried and my dad is US citizen. My chargeability area is Ghana. I am documentarily qualified since November 2022 and my priority date is May 2016. When do you think my interview will be scheduled? Thank you. Paul, you're very welcome. Thank you for your question. So you see it's the same category as I was responding to Hazard. So also documentarily qualified, also back in 2016, only this one is in May. So because right now it's December 2014, the priority date, the current priority date, we are looking at about a year and like 6 months. A year and 6 months. So Paul, roughly, judging by the visa bulletin, December 2014, F1 all chargeability area, you're looking at another roughly year and a half before your immigrant visa becomes available, before your priority date is current. But again, please keep in mind that backlog unfortunately keeps accumulating. It only gets worse, unfortunately. So you might see some extra few months accumulate as you are waiting. Because, for example, between May and June, there was no movement at all, and that's not good. That's the backlog accumulating. Okay, moving further to Mahdi. I-90 is for renewal of 2 years green card or their other form. So that was on the how to renew green card 2022. Yes, Mahdi. So I-90 is the form that you want to use. I'm pretty sure you are able to file it online. Let me double check. I'm going to use this as an opportunity to demonstrate some navigation on USCIS.gov, which is the official government website for U.S. Citizenship and Immigration Services. We're going to go to Forms, All Forms, and then you can type in 90 here, or you can scroll down. This is alphabetic numerical order. Yes, there you go. So it is possible to file online, but I'm going to open, you see right here, what this form can help you do. Renew or replace my green card. That's what you need. So yes, Mahdi, definitely it is. Let me put this, and in fact, I'm gonna put the link here as well for you so that you could just click on it and start your application process. Boom, there we go. All right, so let me copy this back here and let's move on to the next question from Farida Kathawala. Sorry if I'm mispronouncing the name. Hi, have been documentarily qualified since May 12, 2023. How long wait for interview? Wait, please. Okay, Farida. So I'm definitely gonna need your category, because it's really hard for me to tell. You see, if you're not in immediate relative category, right? Not an IR category, but one of the categories that falls under the visa bulletin, then you're dealing with a backlog. And you might be waiting, because most of the times you get documentarily qualified, you are allowed to become documentarily qualified roughly about a year and a half, sometimes 2 years before the availability of the immigrant visa. So if you're dealing with a backlog, you might be looking at another, if you were documentarily qualified back in 1220, well, not 1223, I'm sure it's 1222. You might be looking for as long as another 2 years waiting for an interview. However, if you are in immediate relative category, then you are not dealing with a backlog at all, and you're already documentarily qualified. So the only thing that is left, your immigrant visa is already available. So the only thing that is left is the interview to be scheduled. And it can happen because it's already been 5 months, and roughly sometimes I've seen it take as long as 9 months in the immediate relative category, people waiting for an interview because the embassy was busy. But usually it takes somewhere around between 3 months and 6 months, somewhere around there. And you've been waiting already 5 months. So again, if you're in immediate relative category, you are looking at the interview really somewhere around the corner. If you're dealing with a backlog, it might be much longer than that. So let me know what your category is, and I might give you a little bit more information on that. Just make sure, and that goes for everyone who is watching these videos, make sure please don't respond to my comment within your comment, because I do not see those responses. YouTube don't send me notifications to those responses. If you have a follow-up question, if you have a follow-up information that I've asked for you to provide so that I can give you better estimates, make sure to submit it as a separate comment under any video, and it will show up on this wall right here. All right, let's move on to the next one from Arslan. Thank you so much for the answer. God bless you, Arslan. God bless. Thank you very much. I appreciate your kind comment. I'm glad my answer was helpful. Moving further to LMT Coach Adele. LMT Coach Adele, thank you very much for being publicly subscribed. I appreciate it. So Adele says, hi, how long does it take before the I-485 is valid after it has been sent in when filing I-130? Okay, great question, Adele. So yes, so that's a process. You can send them as a package, I-130 and I-485, if the beneficiary is in the United States of America. When the I-485 comes into play is once the I-130 is approved. So once the I-130, everything is satisfied, the initial evidence, everything is good, and USCIS approves the case, they immediately move further on to I-485. So they say it is a combined process, but at the same time, it is still kind of like if you have been filing, if the beneficiary was outside of the United States, you would have been filing the I-130 separately, and then you would have been dealing with the NVC, which is similar to I-485, but because the beneficiary is already in the United States and they are receiving the, instead of receiving the I-551, which is the temporary permanent resident card once you enter the United States, they already received the temporary permanent residence card right away. So that's when the I-485 comes into play. So it's I-130 first, regardless, and then the I-485. But great question, really appreciate that. Let me put this, and we're gonna move on further to Nordia Wilson. Hi, I petitioned for my daughter in 2018. She's over 21. She in F1. How long the wait time is? Nordia, thank you for your question. Let's take a look. So we know that the F1 category for all chargeability areas is December 2014. The priority date that is current as of June 2023, December 2014. So if you have filed a petition back in 2018, it means your priority date, her priority date is back in 2018. So you're looking roughly at another 4 years before the availability of the immigrant visa, before her priority date becomes current. Now, I am thinking that you might not have been dealing with the NVC yet, the documentarily qualification process. So I would recommend checking out that video again that is specifically on becoming documentarily qualified with NVC, just so that you're prepared for that process, so that once the NVC portal is open, because judging by the priority date, I don't think it is open yet. I think you might have been approved already by USCIS, but you didn't get the full access to the NVC portal. But I don't know. Let me know if it's not the case, because sometimes it's really weird to see some of the cases they get the access to the NVC faster than others. So if that's the case, great. But if that's not the case, if you haven't been dealing with the NVC yet, make sure to check out that video. It's called Documentarily Qualified. What does it mean? Just so that you're prepared and have all your documents ready. You know which documents you need to provide. Once the portal is open, you have everything ready. You log in, few days, you submit everything, just get documentarily qualified quickly, get it out of the way, and then just wait for the final few waiting moments before the availability of the immigrant visa. All right, let's move on further to Stanislav 10. Hi, my asylum case has been pending since 2016. Stanislav, I'm very sorry you're dealing with this. Unfortunately, it sounds like you are in the group of those who are in the pending asylum status that has been placed on the background because of the situation with the border, because of the situation with the people that are applying for the asylum. Basically, what happened is that I think I actually, in the video that you have commented on, I think I said that, I explained that there are two different groups of asylum applicants. The fresh asylum applicants that are just now applying right now, that came through the border and right now applying, their cases are being processed super quick, like within 30 days. Their interviews are being scheduled. The downside is, obviously the benefit is that they're processed very quick. The downside is that if it is denied, supposedly you cannot file an appeal with the immigration court. That's it. If it's denied, it's denied. You're placed automatically in the deportation proceedings. Now, with the cases like your case, where people are waiting for, now you're waiting for what? 6, my math is absolutely horrible. 7 years. 7 years roughly you're waiting now, which is crazy. 7 years. But, yeah, obviously it's negative that you're waiting for so long. It's the negative side of it. But on the plus side is that you are still in that group that the worst case scenario, if it is denied, if your asylum case is denied, you are still able to appeal that decision and continue that asylum case with the immigration court. And it is much higher rate of approval of these asylum cases through the immigration court. So again, it's, it goes both ways. Would you rather have it processed quicker, or would you, honestly, the way they did it is not fair. They shouldn't have done it this way, but it is what it is. We're talking about Homeland Security, we're talking about USCIS, we're talking about government organizations. And when it comes to government organizations, the actions of the government organizations, there's rarely anything that makes sense in there, unfortunately. All right, let's move on to the next one from Xandri Erasmus. Sorry if I'm mispronouncing the name. Do you have any info on the H3? Okay, so that was a comment on I-125 petition for non-immigrant workers. So H3 is, I think it's like a trainee of some sort, like special worker. You can find, again, all of the information like I provide from USCIS. You can find the H3, so all you really need to do is we go to USCIS, and right here at the very top of the search bar, H-3, and just hit enter, and the very first, there you go, H3, non-immigrant trainee or special education exchange visitor, and you can find whatever information that you are looking for right here on this page. So let me respond, do this so that I do not forget this, and then I'll type out link and copy this, boom. And if you have any follow-up questions after reading this, you're more than welcome to come back and ask them, and I'll be happy to follow up. Just make sure, again, for everyone who's responding, make sure to submit a separate comment. Okay, moving further to Lisa Hyun. Sorry if I'm definitely mispronouncing the name. I don't even know how to pronounce it. Does it mean USCIS will reject pool standalone cases? EB5 Reform and Integrity Act of 2022. I don't understand pooled in this context. Lisa, thank you very much. That's a great question. So EB5 is the investors. It's for the investors. So basically what they don't like about the investment cases where people pool the money together in order to come out as an investor. So that's what they're referring to. When let's say I want to get an investor visa, right? And I pool money together from other people so that I can reach the certain minimum requirement that they require to qualify for that investor visa. That's the pool standalone case. And yes, they as of into this act, 2022 act, they don't want to do that anymore. I guess I honestly don't know why. I don't know what's wrong with it, but that's the new rule. But that's what the pooled standalone cases means. It's where people, instead of being an individual investor, they pool the money in together in order to meet that minimum requirement. All right, moving further to Anna Rocha. I really do not understand why the COVID-19 vaccine is still required for the people who are applying for immigration visas. Why? Everybody else can enter the United States without being vaccinated, and they can even be COVID positive. But that is fine, right? I pray for somebody to see the light and stop this requirement. I will always be checking for news here. Thank you, Anna. Thank you very much. I appreciate your comment. It's good, and Susie and Jordak, they also agree with this, and I absolutely 100% agree with this. In fact, that's what the video was about. And I call on to everyone who is watching this video. If you have the I-130, at the end of the day, if you want to get vaccinated, of course, why would I have a problem with this? I don't have a problem with this. If you want to get vaccinated, whatever vaccination it is, that's fine. But I have a problem with when somebody, especially government, somebody who thinks that they're government, right? They are trying to force stuff on people, and especially on people that see this as they don't have an option, okay? And I'm referring to family immigration, as of course, family immigration, because you already wait for years. Imagine people that have applied petition for their daughter, for their brother, for their whoever 10 years ago, because there are people like that, and you can see them, you can see their questions in here. I remember when I just started talking about the family immigration, I was getting comments from people that do not know, and they did not believe me. They thought that I'm just making stuff up, that people do not wait. Well, luckily, because I have more and more people who are dealing with family immigration that are finding these videos and commenting on these videos, now other people that see the comments, they see that people really do wait for years and years and years and years. 10 years is not even that bad. Crazy, right? So imagine you're waiting for this long, and then all of a sudden somebody decides that all the requirements that there were already present, that you did not want to deal with, now there is additional thing that you need to get, which you don't want to get. I don't want to get a vaccination, and I never gotten one, and I never will, and it is my choice. How is that can be anybody else's choice over mine, what I am getting injected or not? It's ridiculous. Even the existing vaccines that are on the list that you're basically forced, because it's not a choice, because if you don't get them, you will not get your permanent residence card. If you are, if you're immigrating to the United States and you are filing, you're applying for a permanent residence, part of that permanent residence application is getting all of these vaccinations. When I was going through this, I have filed a waiver, and it was denied. So I wasn't given that choice. I was applying for that waiver based on religious beliefs, and I wouldn't necessarily call it religious beliefs, but I do believe in God, and I don't just believe in God. I know that God, if I need to be sick and I need to die from some sickness, then it is so be it. God wanted me to die from the sickness, and I'm fine with it. I don't have any problem with it. But it was still denied, and then I didn't really have an option because, you know, I have children and I need to stay here in this country and work and support them. So I had to go and get all of these vaccinations. So I completely understand everybody's unhappiness with this ridiculous situation, especially considering that this vaccine was already dropped for everyone else. Why are we dealing with it is absolutely ridiculous. So once again, I'm going to ask everyone, I'm going to call on to everyone, reach out. If you're here in the United States of America and you're waiting, reach out to your local elected officials, senators, congressmen, whoever you can find. Just Google it, see who is elected in the state, a representative of the state, and reach out to them and tell them that this is ridiculous and it needs to be removed completely. If somebody wants to get these vaccinations, that's fine, completely go for it. You know, it's your choice. But if you don't want them, you should not be forced into any of this stuff. Okay, let's move on to the next question from Ann9742, and I think it's going to be our last question for today. And thank you very much for being publicly subscribed to this channel. I really appreciate it. Ann says, great video. My question is, what the category for information about your eligibility question 27 and 28 if the person filing I-485 based on I-140? How do I complete question 27 and 28 on the I-765 application form? Okay, so let's take a look. So let's see. So 27 and 28, eligibility question 27, if the person filing I-485 based on I-140. Okay, so I-140, so you're, it's a work-based petition based on employment-based petition. So I-485, obviously that's the application for permanent residence. So now I don't think you're permanent resident yet because you're still filing the 485, but you're applying for the employment authorization. So let's take a look. Let's go to the actual application. We're going to go to forms. We're going to go to all forms, 765. And I'm going to actually open the paper application so that I can take a look at what the question is specifically. I kind of suspect that it's about the status and the situation. So let's see. 2728 eligibility category. Refer to the whom may file the form I-765 section. All right. So let's take a look. Instructions. We need to look at the instructions. And let's see. Forms and documents. And that's going to be, I think it's a good, great question because I do not know. I've never filed based on that, but we will find the answers right now from the instructions, and it will be helpful to see for everyone how to find the answers in the instructions in the through the USCIS website. So all of the first ones, as you can see, is asylum refugee, so that's not the case. Nationality categories, I don't think that's it. Temporary protected status, citizen of Senate, deferred and forced departure, nope, that's not the case. We issue the TPS, so that's temporary protection. Nicaragua, depending on the ticker, that's not it. So that's not, this looks like it's treaty, that's not it. Foreign students categories, again, that's not the case for you because you are not in the student category. So we move further. Category for eligible dependents of employees of diplomatic missions international. Nope, moving further. Aha, there we go. Employment-based non-immigrant categories. Now we are looking where we need to be looking. So B1, non-immigrant, who is the personal or domestic servant of non-immigrant employer. B1, non-immigrant domestic servant of U.S. citizen. I don't think that's the case. B1, non-immigrant employer by foreign, nope. Spouse, nope. Spouse. Nope. H1B principal received AC, nope. Based on filing permanent labor. Based on pending form I-140. Boom. I think this is it. I think this is it. So what you will be putting in here, and I would recommend going through this once again, just to be on the safe side. Just go through this and, you know, make sure that, you know, you read it and this is 100%. But from what, you know, from your comment, that's what it sounds like based on pending form I-140. Or based on filing a permanent labor certification. No, never mind. That's permanent, not residence. That's permanent labor certification. But let's see, petition facing completing circumstance, approved employment base. Although, you know what? It might be the case that you are here because you are not a pending form I-140. It sounds like you are already, your I-140 has been approved and you're filing for initial application. So you may be eligible if visa number is not yet available to you, may be eligible if you have not filed Form I-145. Nope. Renewal application. Supporting evidence of the principal. Let's see. So it's going to be one of these. It's going to be one of these. I would recommend reading through, actually, from here. So page 7 of 27, I would recommend reading through and seeing which one is applicable to you. I'm going to do this. Respond with this and put the link in here so that you can read through it and see which one is more applicable to you. Let's see, this is page 7. So page 7, link, there we go. And you will be able to find the correct category for that question on the application. So thank you everyone for tuning in today. If you have any follow-up questions, do not hesitate to ask them in the comments below. As always, appreciate your time. Appreciate you all tuning in. God bless, and I'll see you in the next video.